Hello everyone, good evening. Today we'll be dealing with a very important piece of legislation, that is the Mediation Act of 2023. Now, before we get into the specifics of the Act, let's do a small revision or let's revisit what we've already studied. So, mediation is a voluntary, confidential process where a neutral third party, that is the mediator, helps the disputing parties reach a mutually agreeable solution. Now, the important takeaways from this point would be that A, mediation is a voluntary process, B, it is a confidential process, C, that there's a neutral third party involved, who we term as a mediator, who helps both the disputing parties reach a mutually amicable solution, which is a win-win solution for both the parties. Now, it offers an alternative to litigation, saving time and money. As opposed to litigation, as we've already dealt with in week 2, as opposed to litigation, mediation is a more cost-efficient and time-efficient manner of resolving disputes. Mediation fosters better communication and understanding between the parties. Mediation helps both the parties to realize to communicate with each other and to communicate with the mediator in order to reach out to a mutually amicable solution, which is a win-win situation for both the parties, and it also helps to preserve the relationship of the parties. Now, the Mediation Act was enacted in September 2023. The main aim of the Act is to promote and facilitate mediation for resolving disputes, both commercial and non-commercial. So, whether the dispute is of commercial nature or a non-commercial nature, the aim of the Mediation Act is to resolve these disputes by means of mediation. It also provides for a legal framework for enforcement of the mediated settlement agreement. Now, the outcome of the mediation, which is in the form of a mediated settlement agreement, the Act provides for a legal framework for enforcing these agreements. It also establishes the Mediation Council of India for the registration of mediators. Plus, this Act also encourages for community mediation and online mediation, which is a must-have in the current times. With the growth of technology, it is very, very important to have the provision of online mediation. Now, these are some parts which we'll be dealing in the later parts of the videos, where we'll be talking about Mediation Act in depth. Now, first we'll go into chapter 1 of the Act, which is the preliminary section. Now, this part says that the Act first would be called as the Mediation Act of 2023. It also specifies the Act's short title, extent, and commencement date. Now, when we talk about the extent, this Act extends to all of India. It is applicable throughout India, and it also talks about the date of commencement, which is yet to be notified by the central government. Now, there are some provisions of the Act which have been enacted, whereas major portions of the Act are yet to be, there are major provisions of these Act have yet to be come into commencement, and they are yet to be notified by the central government as to when the Act would come into force. Now, the provision also outlines the circumstances in which a dispute can be referred to mediation. This is a very important section which will tell us which disputes can be referred to mediation. Now, the first is where all or both the parties habitually reside in or are incorporated in or have a place of business in India. Now, all or both the parties, if they have their place of business in India, then they are eligible for mediation under the Act. The mediation agreement provides that any dispute shall be resolved in accordance with the provisions of this Act, where the mediation agreement itself provides, with the contract between the parties itself provides, that a dispute would be resolved by means of mediation under the provisions of this Act, then it can be referred to mediation. Thirdly, if there's an international mediation. Now, international mediation is a situation where either of the parties, one of the parties is at least from a country other than India. The international mediation has been specifically defined in Section 3 of the Act, which deals with the various definitions that have been provided under the Act, wherein one of the parties to the dispute is the central government or the state government or agencies, public bodies, corporations, and local bodies, including entities controlled or owned by the government, and where the matters pertain to commercial dispute. Now, this point says that where the parties, one of the parties to the dispute is either the central government or the state government or corporation or the local bodies or entities which are owned or controlled by the government and which pertains to a commercial dispute. Lastly, the dispute can also be referred to mediation if it is any other kind of dispute, if deemed appropriate and notified by the central government or the state government from time to time for resolution through mediation under this Act. Now, if the central government or the state government notifies that a certain kind of dispute can be referred to mediation under this Act, then that dispute can also be referred to mediation under this Act. Along with that, Chapter 2 also provides and also tells us that about pre-litigation mediation, which means that the disputes that can be mediated before any court proceedings begin. So it allows pre-litigation mediation. This part also empowers the courts and the tribunals to refer parties to the mediation at any stage of the proceedings. The important part here is at any stage of the proceedings. So the courts and tribunals are empowered to refer the parties to mediation at any point of time, any stage of the proceedings. And it also excludes certain disputes from mandatory mediation, which includes disputes which are more often of criminal nature and or matrimonial matters. Lastly, it also talks about various definitions. Now, the most important definition here would be the definition of mediation provided under the Act. Section 3H defines mediation and includes a process, whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby parties attempt to reach to an amicable settlement of their dispute with the assistance of third person, referred to as mediator, who does not have the authority to impose a settlement upon the parties to the dispute. Now, mediation, as it says, it's an inclusive definition which talks about a process where we can either refer it to mediation, pre-litigation mediation, online mediation, community mediation, or conciliation. In all these cases, mediation would mean the same, which is a process by which the parties try to resolve their dispute in an amicable manner with the help of a neutral third party, and that neutral third party does not have the power to impose the settlement on either of the parties. It also talks about various other important definitions, which include the definition of court annex mediation, which means mediation including pre-litigation mediation conducted by the mediation centers established to any courts or tribunal, which means it includes, again, it's an inclusive definition whereby mediation includes pre-litigation mediation, which is conducted by mediation centers established by any court or the tribunal. 3F, Section 3F of the Act also defines institutional mediation, which means mediation conducted under the aegis of a mediation service provider. Now, if the mediation is provided by a mediation service provider, then it would be an and institutional mediation. Lastly, the Act also talks about international mediation, which we've already discussed, wherein one of the parties is from any country other than India. So, the Mediation Act of 2023 marks a significant step towards a more efficient and amicable dispute resolution system in India. By promoting mediation, the Act can save time, money, of the parties involved in the dispute. It fosters better communication and understanding, leading to more sustainable solutions. Now, it is pertinent to note that all the provisions, as we've discussed in in the part 1, in chapter 1 of the Act, that the Act has yet not commenced and the central government is yet to notify the date from which it will come into force. Only a small portion of the Act, some sections of the Act have come into force which have been notified by the central government. This act is in itself is a very large step towards the legal framework of mediation in India. And once the act comes into force, it would serve as a very important instrument to save the time and money of the parties, as well as to preserve the relationship and to resolve the dispute amicably, so that there is a win-win situation for both the parties. Thank you.